questions, but right at the outset, I have to make clear that we're not here to try and give you judgments and decisions on individual cases. Because ultimately that's a decision for GCC or the relevant authority under which you're dealing. And ultimately it's their view and only their view that counts. But what I would hope is that we will give you some guidance and some steer and some examples on how various circumstances and situations might be viewed so that you'll have an idea of how this would work. So we've resisted running this session because it's such a contentious subject. So what I would just do is start by saying that we need to remember that the gifting of our money or our assets is not illegal. It's our choice entirely what we do with our own money. The only thing is we have to appreciate that there will be circumstances where the law will need to be a consideration. So one example of that is tax. If we make gifts, then there may be circumstances in which those gifts are added back into our estate for inheritance tax. Another example would be gifts that are made by a person who is a power of attorney. We need to remember that you cannot make gifts as an attorney. And even if you did have their approval, that doesn't mean that a gift you make couldn't still fall on those. And of course, making a gift at some point before you make a claim for care funding support from your local authority is another example of where the law intervenes with the issue of gifting. And of course, that's the one that we're going to be focusing on today. So what is deliberate deprivation of assets? Let's just make sure we understand exactly what it is. Now, there are two types of deliberate deprivation within our current system. One applies specifically with benefits, and that is slightly different to the issue of care funding. So today, because time dictates, I'm only going to deal with the issue of care funding. And what is it in simple terms? Well, the definition is where a person has intentionally deprived themselves of or decreased their overall assets in order to reduce the amount they are charged towards their care costs. So that's the simple definition. But of course, behind that lies all manner of complexities. Should you wish to read, the legal reference for that statement is in the Care and Support Statutory Guidance, Annex E, paragraph 6. It only says that, it doesn't give you a lot more information. And that really is the essence of the problem. There is virtually no case law on our statute books about deliberate deprivation and care funding. And the main reason for that is because of the costs involved in trying to appeal a decision, of which I will come back to that subject and explain a little bit more of that later on. So we know what it is, but the legal position be determined. We go about whether the act of making a gift as deliberate deprivation. And the answer to that, sorry about my phone, the answer to that is that there are three questions that need to be considered. And importantly, all three need to be present for deliberate deprivation to be deemed to have. So let me just take you through the three. The first one is, was avoiding or reducing the care and support charge a significant motivation in the disposal of an asset? So that's the first one. The second one is that a second question is, at the point the capital was the person have had a reasonable expectation that they would need care and support. And the third requirement is, did the person have a reasonable expectation of needing to contribute to the cost of their care needs? Now, you probably already noticed, but within those three requirements, each one has an extremely subjective description. who decides that avoiding care fees was a significant motivation, or if the person had a reasonable expectation of needing care. And really, it's because of those subjective statements that there are many arguments and disputes that arise in this subject. Now, it is important to appreciate that just somebody has made a gift, authority shouldn't automatically assume that deprivation has taken place. The trouble is that the minute the local authorities see that a gift has been made, it's kind of their natural assumption that it is. If it looks like deprivation, then the likelihood is that they will claim that that's what's taken place. But if they do decide that they want to treat a particular gift or transfer as being an issue of deprivation, then they must say so in writing, and they must explain in writing. It's not good enough for them simply to say, we believe it's taken place and therefore we're not going to fund your care need. So although they have their reason, it is important to understand that the burden of proof is on you, the individual who has made the gift or who has received the gift. But in that burden, you are only required to do so on the balance of probability. In other words, that it is more likely to have been deprivation than for it to have been. So as I would hope you are now beginning to see, there are so many different ways to interpret things when you apply these various rules, definitions, and descriptions. And as I've said already, this is why we have so many difficulties with this subject, and it caused such dispute and argument between individuals, families, and the local authority. So let's try and go through these issues in a bit more detail. On the issue of motivation, which was the first one, was avoiding care fees a motivation, a significant motivation in the disposal of assets? Important to remember that the local authority only has to show that the avoidance of care was a significant factor, but not the only one. So you might make a gift that is perfectly fair, perfectly reasonable, but that doesn't mean that avoiding care couldn't still have been a significant additional motivation. I will give you some examples of these. So let's take the example that your son or your daughter loses their job, they're made redundant, and they face the risk of losing their home because they can't mortgage, and you decide to lend them, give them to them £20,000. That's a perfectly valid and reasonable thing to do, but you've got to consider the circumstances at the time it takes place to decide whether those other factors are relevant. So if you happen to be 80 years of age, or if you're 63 and you've just had a stroke, and therefore the whole issue of care is kind of in your sphere of consideration, then the local authority would look at those factors and say, well, did that perhaps form part of your reason to make this gift? Fairness is an issue that we do come across quite often as a reason to make a gift. I can best describe this with a simple case study that I had from several years ago, where a gentleman with 3 children decided to use the money that he released when he downsized his property to make a gift of £10,000 to each of them. I think if I remember rightly, the reason was to help them either buy a house, upgrade their house, build an extension, but he wanted to be fair to all 3 of them. And the first 2 gifts were made quite soon after he downsized, but the third one didn't take place for 8 years. And the reason for that was his daughter had a job where accommodation was provided through her work, so she didn't need or want to buy a house. 8 years later, her situation changed, and her father came forward and said, here's your £10,000. The problem was, by that time, Dad had developed a care need. So at the time of the final gift, two of the three elements of deliberate deprivation had been satisfied. He knew that he needed care, and he knew that he would have to contribute to his care. But there was still the third question, which is, was avoiding care fees a significant motivation? Well, the motivation to make this gift was taken 8 years previously, when the gentleman didn't have a need for care and those circumstances didn't apply. So the family made an application to the local authority, who looked at the situation and deemed that deprivation had taken place. However, they did revise their decision when challenged. And the argument that was put forward was that the final gift was a commitment, a liability, if you like, because he had documented his actions and his promise to his children at the time, when he had no expectation of needing care and no awareness that gifts would increase his entitlement to state funding. So, in fairness, the local authority, when presented with those considerations, decided to change their mind and not treat the transfers as deprivation. But as that simple example shows, how difficult it is to make an assessment when you take into account the huge number of different circumstances that could prevail with any transfer. So let's look at situations that are the most likely to be deemed to be deprivation. Because really our aim today with this is to give people a steer to avoid falling into situations unwittingly that might then be treated later as an act of deprivation. So we can turn back to the law, which states quite clearly that people should be treated with dignity and respect and should be able to spend the money they have saved as they wish. It is, after all, their money. So that's the starting premise of this whole situation. But as I've said, the act of deliberate deprivation can be more easily claimed by a local authority if there is no other reason for a gift to have been made. If you just do it randomly, then you're really giving your local authority the opportunity to say, we think this has been done in order to reduce your estate in case you need care. So as I say, there are some obvious actions that would attract attention from the local authority. So if you just decide to move all of your money, £100,000 is moved out of your bank account into your son's bank account, or you decide to transfer the ownership of your house to your daughter, or you move money into trust, all of those things are going to create an alarm bell around them to say, has deprivation taken place? The first question to ask is, well, why did you do it? And people get a bit confused here. A good example is I meet people who say, well, I'm gifting £3,000 a year to my son and £250 a year to each of my grandchildren because that's the annual gift allowance. And that's absolutely correct. But these are not rights or entitlements. These are inheritance tax exemptions. So if you don't have an inheritance tax liability, then the local authority could argue that there is no reasonable basis for you to need to use them. As I say, transferring a house under the argument that it's important to me that my son inherits my property, that's likely to fail the test of deprivation, because the local authority would turn around and say, well, you could have very easily done that simply by leaving the property to them in your will. So there are some really obvious actions that will, as I say, attract attention and leave you exposed to the challenge that deprivation has taken place. But let me give you some less obvious ones that, again, are potential pitfalls. Let's take the example of someone who decides to sell their property. Let's say mum decides to sell her property and to combine the proceeds with the sale of her son and daughter-in-law's house so that she can buy a larger property and one which has an annex in which she can live. Perfectly reasonable, sensible, not uncommon thing to do. The problem is whose name goes on the deeds of the new property that's purchased. And the position is quite simple. If mum's name is not on the deeds, then the money that she got from her house sale, which she then put into the new property, will be treated as a gift because she doesn't own anything anymore and therefore is exposed to the issues and problems of deprivation. What would be far better is if mum actually put her name on the deeds and stated that her share of the new property was whatever proportion she'd put into the project. So if she provided 30% of the funding, then she should legitimately own 30%. That's then not a gift. She simply sold her first house and bought an interest in the second one. And what would happen if she then needed care is that you would be having the conversation with the local authority. You would say, well, we want to take the house into consideration. What is it worth? And the answer is, you've got to sit down and work that out. Now, it's important to remember that a £300,000 property in which you own a third is not necessarily worth £90,000. It could be worth anything from £90,000 right the way down to nothing. You imagine putting an advert in the local estate agent to say, for sale, 1/3 of a house with a sitting tenant of your son and daughter-in-law and 3 grandchildren. I don't think you'd be overrun with offers of people wanting to pay you £90,000 for it. So by pursuing the right course of action and documenting the fact that you have sold your house and bought a new one, but in a different combination, is far, far safer and far less likely to cause problem than simply transferring the money and leaving yourself exposed to this argument that a gift has been made. So what we're finding is that local authorities are getting ever more inquisitive. And I look at lots of financial questionnaires that they send out, financial assessments. And many years ago, the question just started off, do you own a property, yes or no? Now it says, if no, did you ever own a property? And if yes, where is it? Or what did you do with the proceeds? And this is understandable because the authorities are under huge financial pressures to make budgets stretch further in the face of ever increasing demand. So if you do it correctly, there's a much better chance that you will not fall foul of the rules. Another example, which I think is a worthwhile one, because it's quite common for the sort of people of the current care generation, and that's something called an investment bond, quite often a life assurance contract, provided by all the insurance companies that we know, Prudential, Standard Life, Aviva. These were very, very common 20, 25 years ago. So lots of people going into care now may have bought one of these or invested some of their money when they retired into one of these bonds. And they're peculiar, these bonds, because they technically have what's called an element of life assurance. It's very, very small. When you die, you get 0.5% of the value of your bond as a kind of life assurance policy. But these were created because they have quite favorable tax treatment. So it's quite common for people to have them. And because they have this life assurance element, the odd thing is that they are exempt from the capital needs test under local authority assessments for care. So you could have £250,000 in one of these things that you put there 20 years ago, find yourself needing care today, and the local authority are obliged to ignore the value of that bond because of its status. But let me give you an example of how that can go wrong. We had a situation with a lady who had done exactly that. She retired 20 years earlier, bought one of these bonds, and then she went to see her financial advisor, or rather her son did, who suggested that there was a different bond, same concept, same structure, but with a different company in a different place that they thought would do rather better in terms of the investment returns that they offered. So they sold bond A and bought bond B, and that was the end of it. But unfortunately, the situation was that the local authority viewed the first bond as being exempt because when it was bought 20 years earlier, the lady had no expectation of needing care. She was still 65, wasn't an issue. But they decided to take the view that the switch from bond A to bond B was deemed to be deprivation because at the time she did that, she was in care. She knew that bonds were disregarded, and therefore they claimed that deprivation of assets had taken place at that point. Now, when I tell you that in this instance, £200,000 was the value of the bond, so what had effectively happened is the lady had inadvertently, on the advice of her financial advisor, transferred £200,000 out of a bond that was perfectly okay and exempt and moved it into one that wasn't. So the cost to her of that decision was £200,000. The local authority said, no, we're not going to pay. You need to come back to us when that money has been spent. Now, in fairness, that was entirely the fault, in my opinion, of the financial advisor who should have known that. But of course, he wasn't a specialist. He just dealt with general issues, didn't know it was a mistake, but a very costly one. So you have to make sure that when you're getting advice on these subjects, you get it from people who know what they're talking about. Because if you don't, it's ever so easy to make a catastrophic mistake on which there is really no going back. Another example or another illustration of what isn't classified as deprivation are goods and chattels. So anything that you have bought or own of a personal nature, personal possessions are exempt from the means test. And some people see that as an opportunity to take advantage. So if you go out and buy yourself an original Lowry to hang in your hallway, because that moves £200,000 out of your cash account into the goods and chattels category, then expect the local authority to be knocking on your door to say, excuse me, why have you done this? And again, you fall into the radar of this being an act of deprivation. The same applies with assets that you've already got that you try to sell for a reduced value. I'll give you two examples. One is where you transfer, your house might be the typical example. You decide to transfer your £300,000 house to your son at a reduced value of £200,000. That is an act of deprivation in the eyes of the local authority because you've sold it for less than its value. You could even have the same thing if you, it's a bit of an odd example, but if you happen to own a pair of Chinese Ming vases and you decide to sell them separately, the fact is they would be worth significantly less as two single items than they would be as a pair. So these are examples of where you're reducing the value of your assets, not necessarily giving it away. And speaking of giving it away, probably one of the most common ones is inheritance. So if we take the example of you being a beneficiary of somebody's will. So let's say you've got a lady who is elderly and her sister dies and leaves her £100,000 in her will. You may or may not be aware that there is a legal format whereby the person receiving such a payment can actually decide to not receive it. You can almost go back, if you like, and change the person who's died, change their will so that you don't receive it. It goes to your grandchildren or the dog's home or whoever it is you might prefer that money to go to. And that is a perfectly legitimate process called a deed of variation, used commonly for people who are planning for inheritance tax and want to kind of skip the generation. But in care terms, it is an act of deprivation, because had you not done that, that lady in the example would have had £100,000 more in her estate than she has now because she has deprived herself of that inheritance. Now, if she already had £300,000 of her own money, it wouldn't make any difference. The local authority wouldn't be interested because she would be self-funding. But if she had no money or £10,000, suddenly receives this inheritance and says, oh, please don't give it to me, otherwise I'll have to pay for my own care. So can I redirect it to some other member of the family? Then that is likely to be viewed as deliberate deprivation. And then the final couple of examples. But again, I'm trying to pick things that people do or consider most commonly. Paying back a loan early is also an act of deprivation. So if a loan that you have is repayable on demand and you suddenly find out that you're going to need to move into care and you decide to pay it, no problem. The loan is repayable on demand, not an issue. But if you had a mortgage that was due to mature in, say, 5 years' time and you pay it off early, then there's the potential for that to be defined as deliberate deprivation, because you're thinking, oh, if I pay off my mortgage and my house is exempt, then that'll get rid of some money out of my estate. Unfortunately, it won't, and you're left with the potential that deprivation has taken place. Probably the most common one, and it's not unusual for local authorities to ask for copy bank statements, is if they can see expenditure that's out of character, substantial expenditure. I'm not talking about small amounts. But if you suddenly start sort of drawing out £2,000 a month from your bank account in cash, you would expect somebody to say, excuse me, what's this and why? And I'm going to conclude this little section about potential deprivations with funeral plans, because they are a particularly common subject. It seems everybody I meet is persuaded or asked or advised to buy a funeral plan when a care need appears on the horizon. Again, it's very likely to be viewed as deliberate deprivation. If you think about it from a local authority's point of view, you are allowed to keep £14,250,000 of capital. And when your savings reach that point, you will not be expected to use any of it to contribute to your care. In other words, you will have more than enough, even at today's prices, to be able to purchase your own funeral. So if you decide to buy it now, early, in advance, when you have £30,000 of capital, let's say, what you are effectively doing is you put the local authority in a position where they pay for your funeral. That's effectively what you're doing. That's effectively the view that they would take. And that's not the intention of the care system, and it's not an obligation that the local authority should be expected to accept. So don't be surprised if they look at your situation and see that a funeral plan has been purchased and say, excuse me, we are going to view that as deprivation. So are we all thoroughly depressed now in terms of how we're going to be treated by this system? Well, just in case you're not entirely depressed, let me just mention that everything I've spoken about so far is deprivation of capital, deprivation of assets. We need to remember that deprivation of income is also on the radar. A couple of examples that I would like to give you of that. Going back to my investment bond earlier, those things that people had 20 years ago, because of their particular tax treatment, the most common arrangement was people would put £100,000 into them, and you were then allowed to draw £5,000 a year, or 5%, without any tax issues. And that was very attractive for people who just retired. What I see a lot is that people who are close to a care need, or indeed have a care need, suddenly decide to stop those payments. And again, expect the local authority to come to you and say, why have you deprived yourself of this income? You've had it for 20 years and suddenly you've decided to stop it just before you go into care, or just after you've had a stroke, or just before you need help with domiciliary care at home. So if you're going to stop it well before you need care. And if you stop it close to care, expect the local authority to challenge it. Pensions is a particular subject. It certainly was until the budget last year, because pensions were not included in the inheritance tax regime. A lot of people were reaching retirement and not taking the benefits from their pension. They were effectively leaving that as an inheritance to their family. They were also trying to take the view, well, you can't assess that as part of my income. I'm not receiving an income from it in terms of my overall position. What you would expect now is for the local authority to say, that's fine, you've got £100,000 in the pension, which you are not taking anything from, but we're going to reassess your income as though you were taking what would be a market value income from that pension. So again, it will not go unnoticed. It won't protect it just because you're not taking it. But just as a slight aside, not really a mainstream part of our conversation, I remind people that if you are in care, if you are looking for support from your local authority and you are in receipt of a private pension, if you pay half of it to your spouse, then it must be disregarded by the local authority. So in actual fact, rather than leaving a pension untouched, which the council could then come to you and say, right, your £100,000, we're going to assume you're getting 5,000 a year income from. If you actually took the 5,000 and transferred 2.5 of it to your spouse, then you would significantly improve the way that you're treated. So again, it's about education, about information, and about knowledge to make sure that you're clear about how you get dealt with. And I have to mention just at this point, one, it's a particularly technical point. It may affect absolutely nobody on today's session, but I have to mention it. Payments from discretionary trust. If you or your family or family members put money into a discretionary trust of which you are potentially a beneficiary, in other words, you could have some of the money out, will be excluded from the assessment, providing, and this is the providing, the person in care is not a trustee. So if you have a family situation that is like that, my advice would be go and have a look at it, because it might be better for the person, the older person, to retire as a trustee before they develop a care need, and then that issue isn't going to be open to attack. Okay, what I want to do now is just look at some ways. We've dealt with all the bad news. That's it now. I've given you all the things that can happen that's detrimental. What I'd like to do is just look at some of the issues that are okay, just so that you're aware of the fact that this is not an entirely one-sided process. Now, remember, these examples should not constitute direct deprivation, but you have to remember that all of the person's circumstances will be taken into account. So I have to make that kind of little caveat. So let's say you make a gift to somebody of £500 as a thank you, to say thank you for the fact that they've provided help or care or support. There would be no basis to argue that that should be an act of deliberate deprivation. Another example, if you're in care, if you're in care and receiving support from your local authority in a residential setting, you're allowed to keep something called a personal expense allowance, which is a proportion of the pension income that you have. You're allowed to keep. It's just over £30 a week, and the intention is that you would use that for your toiletries, for your newspapers, hairdressers, that type of thing. Well, £30 a week doesn't get you very far these days. So if you're spending £100 a week, my advice is by all means do so, but document it. So if anybody comes and says, what's this? You can say, well, I've decided I pay for my own health insurance. I pay for my private dentist, whatever it is you do that you spend your money on. Don't leave yourself in a position that it can be open to attack. And perhaps the best example of this is couples who have joint accounts. We see this a lot. People have joint accounts, and one of the parties, one of the spouses, has a care need. And the cost of that care, the things that she has to pay, are taken out of that joint account. I would encourage you not to do that, because in effect, the person who's not in care is subsidizing the person who is or has a care need. So my advice would be to separate the two accounts into two single accounts. Or if you're going to keep a joint account, keep it with a nominal amount of money in, and make sure that everything to do with the person who has a care need is taken out of their account and not the other ones. Now, exactly the same would apply if you own a joint property and it needs to be re-roofed and one of the partners is in care. They should take half of the roof repairs out of their account because it's half their house. So you've got to look at ways to try and deal with your affairs fairly and straightforwardly, but not inadvertently fall into the trap, if you like, of it being classed as deprivation. I mentioned property there, and this is a situation that we see quite frequently. So let's take the example of a typical married couple who own their property together, and that's really their main asset. They might have a bit of savings, but nothing significant. And one of them needs to move into a residential care home. The local authority system would assess them. The house would be disregarded. Its value would not be taken into account because it's occupied by their spouse. And because they have limited assets of their own, the local authority would basically provide funding support for that person. Now, what we find quite often is the person who is at home, who's not in care, thinks, well, this house is now a bit too big for me. It's a bit expensive. It would be a good idea to move to either a more suitable property or maybe to one that's closer to the person in care or closer to family members. There might be a whole raft of reasons. Now, what we've got to remember is the person who is in care is still half owner of that property. So if you decide to sell your £250,000 house in Cheltenham in order to buy a £250,000 house in Forest Dean, because that suits, then that kind of sideways transfer is viewed as fine. But I would always advocate that you should tell the local authority what you're going to do in advance, just so that there's no possibility that they might dispute that later on. Better to get their agreement at the outset. But of course, that's not generally what people do. What people do in this situation usually is a downsize. In other words, they're selling a £300,000 house in Cheltenham to buy a £200,000 house somewhere else. In other words, they're releasing £100,000 worth of capital. Now, what you've got to remember is that half of that money is the person in cares and half of it is the person who is not. So a decision to do that will effectively render the person in care back into being self-funded just because you've downsized. So you have to be careful that things that you might want to do make sense, they're logical, but the local authority has no choice but to say, I'm very sorry, that £100,000, you can't give that all to dad who's at home. It has to go half to each of them. And that same principle applies with equity release, which is a common route for older people who are looking to raise money on their property. Unfortunately, you cannot equity release on half a house. You can only equity release on the whole amount. So again, £100,000 raised would result in the person who is being funded by the local authority would then effectively become self-funding by virtue of that position. So there are things you can do. There are things that you can planned for, but you have to really sit down, think about it, and you have to understand what the likely consequences are. And if I had one general piece of advice to people, it is think not of the current situation, but think what the position will be if, having done what you're about to do, you then needed care in 3, 5 years' time. Now, the longer the time period since the initial action, the better. But I will come to this issue of timing in a moment. What I do want to do is just explain what happens if the council do deem that deprivation has taken place. So the first thing is, as I said earlier, they must explain their reasoning in writing. And you can then object in writing, setting out why you think they're wrong. And the example I used about the chap who made the transfers to his 3 daughters, that's exactly what happened. And when they read it, they said, okay, fair enough, we accept that. If they don't accept it, then you can request an appeal hearing. Now, this is unfortunately very court-like. There's a lawyer representing you and the local authority. There's a panel of 3 people, one who is independent of the local authority. But what you have to bear in mind, and people fall into this trap so often, is that the other side can access your medical records or your legal records. So if, for example, they can show that you made, I don't know, a claim for attendance allowance, or you received a nasty medical diagnosis 3 weeks before you made the transfer, then it will be almost impossible to argue that the requirements of deprivation have not been met, because motivation, circumstances, knowledge are all clearly evident at that point in time. So don't go into that situation lightly. You're unlikely to get too much change out of about £5,000. And really, that's why there's no case law, because people just don't go down that route, because it's usually clear cut as to whether or not you're going to be successful. People ask me, can we take the case to the local government social care ombudsman, the LGO? And the answer is yes, you can, and it's entirely free. The problem is this is not an appeal process. The LGO can't overturn a decision made by the local authority. All they can do is make sure that the decision was arrived at through the correct procedure. So people inadvertently think, oh, I'll appeal here, it's free, and I'll win. They never get overturned by the LGO, unless you have something really knockout to sort of present to them that the local authority, for some inexplicable reason, has chosen to completely ignore. But they can't overturn the decision simply because it's unfair. That's not a legitimate claim, unfortunately. So what happens next? Well, they basically say, right, that transfer of the house that you made 3 years ago, we're going to treat you as though you still had the money or the asset involved. But of course, if you think about it, the person who received the gift may not be able to put it back. They may have spent it if it was cash. It can't be recovered because it's been invested in a business, or it's tied up in a house that they bought. And in this situation, the local authorities still have a duty to pay for care just because they've established that deprivation has taken place doesn't get them off the hook. But they do have the right to seek to recover the money from the person who received the gift. That could be a lump sum. It could be an agreed payment every month. And they do have the right to pursue the Insolvency Act and the county court process to do it. I agree they do that as a last resort very reluctantly, but you do have to bear that in mind. And if you do find yourself in a situation of having to pay back an agreed amount, make sure you keep a really good record, because there will come a point when that asset that's been transferred, that's now being reassessed, as its value or as it's spent down, you will reach the 23,250 point where you would then trigger a legitimate claim from the local authority. So kind of just bear that in mind if you do find yourself in that horrible situation. So my last bit really is just entitled Some Final Thoughts. As you probably gathered, it's a pretty messy system. It's messy for everybody because there's such a lack of clarity. But I thought it might just be worth sharing with you a couple of common misunderstandings. I mentioned time before. Time scale is without doubt the biggest misconception. The number of people I meet who say, but I did that 7 years ago, it's okay. Unfortunately not. The 7 year rule is an inheritance tax allowance to do with potentially exempt transfers. It has absolutely nothing to do with care. I think the longest period of time I can recall in my career where a person has been deemed to have deprived themselves was 23 years ago, because the circumstances at that time were clear cut. So don't fall into the trap of thinking that time makes everything okay. I do agree. The longer the time scale between the act and a claim for care, the better. Why? Because it's easier to argue that you weren't thinking in care terms. If you do this when you're 60, we're not thinking about care. We're thinking about retirement and all sorts of other things. If you do it at 80, it's an awful lot more difficult to overcome the challenges. So as I said earlier, think before you act and consider the whole issue of what, when, and why. That's what's going to be looked at. What have you done? When did you do it? Why did you do it? And you need to make sure that you've got a clear and robust answer. Now, it is fair to say that not every local authority around the country, and there's lots of them, have the same resources. They don't have the same quality of staff. Some are more inquisitive than others. If you were looking at the situation, for example, in the southeast, along the south coast, the legal teams in local authorities are extremely switched on to all of these issues. If you went to Northumberland, where property values are lower, that's likely to not be the case. So it isn't the same everywhere. I've seen people get away with transfers that they made 2 years ago because their local authority didn't investigate enough. But I know if they lived somewhere else, that would not have been the case. I'm also seeing more and more local authorities who are using the argument that simply because you are older, you should automatically know that you're likely to need care and know how the system works. So if you remember those 3 points I made, one was intention, but the other two were about expecting to need care and expecting to have to pay for it. I've seen some local authorities say, well, mum's 78. Of course she would know that she might need care at that age. And of course she would know how the system works. It's readily available on the internet. I've even seen one local authority find out that this person had assisted their mother in a move to care some years ago, and they use that as the argument to say, clearly you know how the system works. So as I say, some local authorities are significantly more aggressive than others. And I would just finish by mentioning something that I come across regularly under the general category of asset protection trusts or family asset trusts. They have various names. I see lots of adverts in Gloucestershire advertising people to come along to these seminars where they explain to you how, by making these arrangements, you can protect your assets from care. The whole world of trusts is beyond the scope of today. We couldn't possibly try and cover that. But what I would say to you is these arrangements, as soon as you write down that that the purpose is to avoid paying for care, you've effectively disqualified yourself because you've given the council the very reason that you did it, which allows them to claim deprivation. There's been quite a lot of outcry about these trusts. There are perfectly legitimate versions of them that are just there to deal with probate. But I would argue that if you're thinking about that or looking at it, tread very carefully and get some expert advice independent of the person that might be trying to sell you this arrangement, just to make sure that you've got your position covered. Because they can A, be expensive, B, not work, and leave you in a slightly worse position than you might have been before. And the final thing I'm going to say, which may seem a little surprising, is a bit of defence for the local authority, is please remember that if you get caught up in this argument, this is not them making a personal attack on you. They're not making a judgment. They're not saying you've done something wrong. They're not trying to say that you've acted necessarily in an illegal or an unlawful manner. Local authorities are required to follow the process that has been set down by our statute. And at a time when funding is under huge pressure, they have more people making requests for support than they have funds to do it. They have no option but to apply the rules as they are directed. They sometimes get that wrong. They sometimes get it right. They're sometimes willing to listen. They're sometimes not. But I just think it's important that, as I said at the beginning, what you do with your money is entirely up to you. All the local authority is saying is if you have chosen to do that, you can't expect us to step in and pay for your care costs. So you must make it an informed decision rather than just do something and then find out afterwards that it doesn't work. So just to conclude, I hope we've at least demonstrated today how this is not a simple or an easy subject, and just how many different views you can have. But I hope at least we've been able to provide you with an overview explanation of what the issues are, what to expect, and how you might hopefully avoid them causing you undue difficulty. So there we are.